Hello, everyone. Welcome to today's program, The New Standard of Care, Federal Cybersecurity Law and the Lawyer's Duty of Competence. I'm Castro, Director of Education and Professional Development at Beverly Hills Bar Association, and I'm delighted to introduce our speaker today, Majo Castro. Majo is the founder and principal attorney of Castroland Legal, where she focuses on cybersecurity and AI law in English and Spanish. Majo advises startups and growing companies at the intersection of cybersecurity, data privacy, emerging technology, and business law. She also advises clients on regulatory compliance, data breach response, governance and risk management, and small business advocacy. We're so excited to hear what she has to share with us today, so I'm going to turn it over to her.
Hi everyone, good afternoon. I'm going to be sharing my slides here. Let's just make sure that we have those on. Can you please confirm that we are all in check, it feels like?
Perfect.
Yes, great. Thank you so much. Well, thank you again. Good afternoon. Thank you to the Beverly Hills Bar Association for having me. Again, my name is Majo Castro. I am talking to y'all today from Austin, Texas. Really excited. I'm the founder and managing attorney at Castroland Legal. We focus solely on cybersecurity, law, AI governance, and data privacy. And how I got to do all of this? Well, I did my master's in law at UT Law here in Austin, Texas, and I'm really excited about it. It's been a journey. And I love sharing my knowledge with my colleagues just so we know what the new competence is. I have a really popular article that I would love to share with y'all that it was published at the Texas Bar Journal. It's called The Newish Cybersecurity Competence for Attorneys, and people have been loving it. I'm gonna share it with the people organizing the program, and that way you can get your hands on it as well. I want everyone to hold on to one sentence for the next 45 to 50 minutes that we're going to be together. I want everybody to know and understand that cybersecurity competence is now a legal competence. It's not adjacent to it. It's not a maybe. It's not it depends on the case. We are now responsible and have a duty to protect our clients' information, and that's all that we're going to be discussing today. And so we can all get on the same page. For years, our profession, of course, have been treating data security as an IT problem. So we thought that by buying the antivirus or getting a third-party vendor, we were covered and we were able to move on. That era sadly is over, and both federal laws and our rules of professional conduct have been really clear about it. And I'm going to show you, and I'm going to be pointing to different regulations and frameworks that are going to confirm what I'm telling you. For quick orientation, you're going to see that my slides are going to be referring to the ABA model rules and the ABA comments, because that's the shared standard that we all have in common. I'm in Texas and y'all are in California. And I know that you have your own rules of professional conduct, numbered a little bit different, but I know that in one way or another, California has adopted the rules that I'm going to be mentioning today. So just make sure that, to point to the right ones whenever you're going over your ethical duties. But everything that I'm going to be sharing is something that we all have in common. And we're going to, at the end, going to get to federal frameworks and to industry international standards as well. So my whole practice here in Texas lives in the intersection. I help firms, law firms, attorneys, and founders hold data without becoming the next breach headline. Well, if they're lucky enough. So I'm not going to be reading the exact statutes to you. I'm going to tell you what the rules mean on a Monday morning whenever you're trying to figure out what you're responsible of. So here's the baseline. So about 20 years ago, if a paper file walked out of your office in the wrong hands, that was an obvious malpractice claim. So we were clear about that. But today, that same harm will look like maybe an associate clicking on a phishing link that hands a stranger your client list by mistake. Maybe your engagement letters and even your pending wire instructions. Another problem that you might be crossing is a third-party vendor that it's having AI embedded into all of their systems and them getting a breach and your clients being affected now. So that's the type of responsibility that I want us to get into today. As I mentioned at the beginning of the presentation, cybersecurity stopped being an IT problem And most attorneys are still treating cybersecurity as an IT issue, and our rules of professional conduct have been saying otherwise. Rule 1.1, it's competence, and it now includes the technological competence as well. Rule 1.6c refers to confidentiality. It is mentioning that this is an active security obligation and not a passive promise to safeguard our clients' data anymore. And rule 5.3, it's talking about supervision. So if we hand our data to a vendor, we stay responsible for what they do with the data at all times. So the federal frameworks will sit on top of these three ethical responsibilities that we have. And behind all of it, it sits one phrase. We need to have reasonable efforts to protect our client information at all times. That is a thread that is running through every item today, more so because we have a bunch of vendors embedded into our environment. And we have also those vendors implementing new technology. Let's call it AI today, but tomorrow can be called a different thing. But the whole premise of the presentation is that we remain the ones responsible as per our ethical responsibilities and federal frameworks of what happens to our clients' data at the end of the day. So today we have a plan. We're going to be chatting in threes in ideally 45 to 55 minutes. And if you have any questions, please feel free to be dropping them in the comments or the Q&A section for me. And I'm going to be reading them as we go. So first, we're going to be chatting about 3 ABA opinions. So that way we get an idea of what our duty looks like in practice. Second, we're going to be chatting about 3 model rules that I've mentioned already. That's where our duty is coming from. And we're going to be chatting about 3 federal frameworks, for what some of your clients and you are subject to, depending on the areas that you are practicing. I think I'm also going to throw in there some of the industry standards. So NIST frameworks that we should be paying attention whenever we are thinking on cybersecurity and we're thinking about privacy. So we are ready to dive in. So part 1, we have the 3 ABA opinions. These are going to be leading the broad duties of competence and confidentiality. And basically, it's going to turn them into do's and don'ts for modern legal tech. So what attorneys need to be doing and not whenever we're talking about clients' data, whenever we're talking about data protection, cybersecurity, AI implementation within our law firms as well. So I'm going to start with Formal Opinion 477R from 2017. Some people call it the wake-up call. It updated the ABA's rules, all 1999 guidance that said that plain unencrypted emails were fine for client communication. Now, basically, we're throwing that out the window. And the holding is that lawyers now must use reasonable efforts. And you're going to be hearing this phrase a lot through my presentation. Reasonable efforts. What are even reasonable efforts? To me, and I'm going to repeat myself, it's to document. So if you're going to make a decision, this is a question that I've been getting a lot here in Texas. So I'm part of the Technology and Computer Commission here for the Texas Bar Association. So we get a lot of questions from our colleagues about technology usage, AI implementation. And the question always is, what reasonable efforts mean? So I'm going to tell you what I tell them all the time. Document. If you're going to make the implementation of a new tool, you need to compare it with something similar that's out there if it is that we have something similar. So for example, if you're making a decision to use a new CRM system, and let's talk about My Case and Smokeball. I think that's another one. If you're making a decision between them two, try to document why you went with one versus another. Literally just a short paragraph can save you thousands of dollars if we have a cybersecurity or a data breach issue down the line. So the holding, back to 477R, the holding was that lawyers must use reasonable efforts to protect electronic client communications. And because reasonableness fact is, is fact specific, there is no single rule that's going to cover what reasonable means. And that's going to be a whole conversation, and I could chat about it for days. But in practice, you cannot treat all your emails the same way, and we know this. So a scheduling email or a draft of a public filing, that's standard email, it's perfectly fine. Or, then we can have a draft settlement loaded with medical records, trade secrets, or account numbers. Well, plain email could fail this standard. We're not being reasonable about the type of communication that we're using in that specific scenario. Now, we're looking at encryptions, secure portals, and maybe another protected channel. So for my practice, for example, if I'm going to share medical information, I am going to prompt my client to use my case portal and upload the documents that, the medical information that we need through the CRM portal versus a regular email. So ideally, and honestly, in practice, I have my clients using my case portal for everything, unless that they're not tech savvy. Then we'll figure out how to help them. So the formal opinion that we're chatting gives us the balancing test: how sensitive the data is, how likely the interception is without safeguards, how much the safeguards will cost if you have to put them in place, and how hard are those, safeguards easy to use for the client. So those are the type of questions that we should be having in mind whenever we're thinking about client communication and protected information. So ideally, we're building a tiering system, so we're not deciding on email by email. So tier one, for example, could be routine admin, standard emails. Tier two might be client matter updates. We can use a secure portal. And tier three can be high risk, M&A, protected health information, or personal data. Well, in that tier, we should be using encrypted and behind multi-factor authentication, maybe. So, and again, it all depends. And the biggest mistake that I'm seeing is that lawyers assume that the email provider's default settings are legally enough, and they're not. So if we ever face a complaint after an incident, the question won't be if we were hacked. It'll be, well, were you making and taking reasonable efforts and documented your decisions for you to have avoided this scenario? Because even if, and it's technically, it's going to be impossible for us to get hacked. Everyone's going to have it at one point or another. The question is if you use and implemented reasonable efforts and you documented your decisions. So for 77R, it's about prevention, and now we're going to be moving on to opinion for 483 from 2018. And well, this is going to be applicable the morning that your prevention methods fail. So there are four duties that are going to be triggered the moment that we discover a breach within our system. So one, we're going to have to monitor. We have to be able to detect a breach. I didn't know it's not going to be a defense if we never set up the monitoring in the first place. That is going to be ideally handled by IT. If you're a growing law firm like I am, I have someone that I had, I have a third party vendor. I already vetted them. I documented my decision as to why I chose them over someone else or another group. So, that's done. Two, we need to stop and restore. So the second that we detect the breach, we have to contain it and we need to bring the systems back. In practice, that means, well, calling the outside incident response firm and breach counsel. And this is going to be the first time that I'm going to mention that if you do not have a cybersecurity insurance in place, it is my best recommendation for you to start to, browsing for one. Ideally, you have about $1 to $3 million in coverage. And ideally, you are selecting your breach response counsel and your forensics counsel before the breach happens. Right now, I've been working on an incident response plan for a technology company. One of my biggest clients here, we've been working on their incident response plan for about 2 months at this point, and every time that I think that we're almost ready, there's a gap, there's someone that we haven't defined yet, there's a tabletop exercise that we have to execute to make sure that the plan is actionable. So yes, these things are going to take time, but believe me when I tell you that while you're working on the implementation of monitoring, of selecting your vendors, of drafting your incident response plan, you're going to be working and understanding where your gaps are laying. Three, we need to determine what happened. So we need to investigate the scope of the breach when we have it. We need to try to determine, not try, we have to determine what systems, what files, whose data, was affected. Without that information, we cannot even meet our notifications duty. And that it's ideally why we're working on an incident response plan that it's already telling us what our duties for notifications are. My client has 45, I think it's a 52-page document by now, in where, the exhibit pages have already the notification templates. So we don't have to be thinking on the spot in the middle of a breach what to say to the clients whenever we do decide that it's time to communicate with them, if we get to that point. And four, we need to notify under Rule 1.4 whenever we have an independent ethical duty to tell all affected current clients when their information is material or materially, compromised. Then again, we have to determine within our own law firms when we're going to trigger Rule 1.4, because if I have 5,000 clients and only five of them were affected, then we have to have different triggers. Who's going to notify what type of communication are we going to tell them? Ideally you're letting the client know, hey, this happened, but these were the remediation measures taken, so you don't have to worry about A, B, and C, so we can put them at ease. That ethical duty exists separate from any state breach notification statutes. We can hit a spot where a state statute's threshold is not met. So, for example, in Texas, I think I need to notify the AG's office whenever more than 500 clients are affected. But maybe my ethical duty says that that my local ethical rules or local opinions say that I have to notify whenever, I don't know, 25 clients are affected. So we still have to notify clients sometimes whenever even the regulatory threshold is not met. And that is why we have to have a good incident response plan in place that is adjusted to you, your practice, your state, the type of law that you are practicing. That way it is an actionable plan. Every time that I do these presentations, I get literally every time, it works like a clockwork. I get about 5 emails of people requesting me an incident response plan template. I can definitely share it. I don't have a problem, but the template that I have here in Texas with my vendors, with my regulations, with my opinions here in the state of Texas are going to be completely different that you have in California than we have in any other state. So just keep that in mind. So the move to comply with opinion 483 in our ethical rules, ideally is to write an incident response plan before we need it. And it's really important for us to try to understand that before we need it. So 3 things at least need to be listed on a decent incident response plan. Who to call first, cybersecurity carrier, breach counsel, incident response firm. We need to ask ourselves, how do we preserve the forensic evidence? And who approves the client notice? Who is responsible for the client communication? Because with every breach that we get, we also need to be thinking about the reputational damage. To me, that is the most important and most delicate one of them all. We're attorneys, accountants, we rely and depend a lot on our reputation. How would you feel if me as a cybersecurity law firm will get breached and you are part of it and I am not even communicating with you? I don't have an internal process for it. That'll be terrible for my reputation. It'll be terrible for my firm, And these are things that now attorneys need to be thinking of because in the past, as I mentioned, we will outsource it to a third-party vendor, to an IT technical team, call it a day, but that it's not it anymore. We have to be involved in the internal processes. We are the ones that ideally are building our incident response plan from scratch and with plenty of time. So we not only build the plan, but we put it in motion. We have tabletop exercises. We train our personnel. So there is an associated thing with the with the drafting of an incident response plan, that it's not only, write a 25-page document and that's it. And the one that takes over every Q&A that I have and that I've had lately, it's going to be the Formal Opinion 512. That it was, I think that came out in 2024. It relates to Gen AI. So it invents zero new rules. It basically maps the duties that we already have onto AI. So the six rules that Opinion 512 is touching is competence. So basically, we need to understand the tools, capabilities, and limits. Two, confidentiality. So now we need to know how the tool uses the input data. So if we're using any AI or generative AI tool, we need to ask it, in the background, one, please do not train your model with it. And two, ideally, we have a DPA in place, a data processing agreement in place. And that is why it's good to have the team or the corporate versions of it versus the free unpaid versions. It also touches communication. So basically, disclose AI use when it's material to the client. And honestly, I am big on transparency in my law firm. That's all that I care about as well with my clients. So I already added an AI clause at the beginning of the year, and I let my clients know, hey, by the way, we are using AI to do these determined tasks whenever, potentially with your data. Are you okay with that or not? And we allow them to pick and choose. We allow them to be informed, even though that I might not even be using their data for anything material. So that is on the transparency side. Another rule that it touches is candor. We need to verify the outputs. We know that hallucinations are not a defense anymore. I don't know, it's not a defense. We've seen it. It's not new. It's only going to get worse. And we don't want to be on the next headline. So check and check and verify. It's always a good practice. It's also touching on 5.1 and 5.3, supervision. We need to train our staff, we need to set a policy, and we need to vet our vendors. One thing that I've been seeing a lot, people not vetting their third-party vendors, thinking that because you are choosing a third-party company, the responsibility is on them. And not really. Now I see a lot of security questionnaires floating back and forth. Even I had a client asking me for my security measures, even before, of course, it was a big company. But even before they engaged me, they sent me, I think it was a shorter questionnaire. It was less than 20 questions, but they wanted to know, one, you have an incident response plan in place. Two, have you, when I think they asked, when did I have my last tabletop exercise on security in? Three, what systems, what AI systems are we using, and so forth. And we're gonna start seeing this more often, and we need to be ready to ask those questions. So whenever we are talking about, and this is extra that I'm throwing at you, but because I know that lots of firms are implementing AI, ideally you have an AI inventory. You have an inventory, you know who has access to what, you have a policy in place, you have training. That way, whenever the questionnaire comes, because they will start floating around more often, you are confidently able to answer those questions to your potential clients. Another rules that it's touching, of course, fees. We are not billing for time saved by AI. It was maybe a month ago that I saw someone on LinkedIn with lots of followers say, or basically complain as to why he would have to stop charging time, for the time that the AI saved if he had to, review everything that the AI system did. And those are that's a twofold question. One, the AI system is working for you while after you gave it the prompt, and two, then you have the supervision time. That is a time that we charge for. But it was just was curious to see how people in the comments had a lot of opinions on this. So just to clarify, bar associations and opinions have come out saying that we cannot charge for the time that the AI saved us. That's just a common ground these days. So we're gonna get into the model rules, where the duties are coming from. And I know again, I'm chatting with y'all located in California, but your state has adopted these rules in one way or another. So we saw how this plays out through the opinions. Now I want to anchor, what I just mentioned to the rules themselves. And remember, California, I think it has rule 1.1, 1.6, and 5.3. Please double check and verify that, they carry the same duties. And, I'm going to mention a couple things that I read about California as we go. Um, so, including California, our Supreme Court adopted this language in, sorry, give me just a second. We talk about generative AI, part two. Okay, so rule point one, comment eight. It's the competence rule that, this is a teeth for the modern practice, here in comment eight, added in 2012, and it's now, I think, taken by more than 40 jurisdictions, including California. So our Supreme Court adopted this language in 2021 as comment one to the California Rule 1.1. So it made California, I think, the 39th state to put technological competence in writing, and California got there even earlier through other formal opinions that y'all had. So the language basically says that we have to stay abreast of changes in the law and its practice, including the benefits and risks of relevant technology, and that it's not only applicable to AI. Today we can name it, it's AI. Tomorrow it's going to be a different beast because how we see that everything is quickly changing. Believe me, we're going to see technology that we've never seen before. So we need to start implementing policies within our law firms and training to our personnel that are a little bit more broad than AI itself. Just implement it to new technology. I'm trying to start doing these presentations with a more broad, concept. So I talk about implementation of new technology instead of AI, and I'm trying to be a little bit more broad with my policies because of the same reason. So the comment eight paraphrase says that we have to maintain competence. A lawyer should keep abreast of changes in the law and its practice, including the benefit and risk associated with the use of relevant technology. What this means for us is that technological competence is now a baseline and it's not optional anymore. And I know it adds a lot to our plate. We have already a lot of things to do on the daily, but now we also have to worry about if our paralegal is using AI or not, and if they're using it correctly. That's also part of our competence problem. Two, we must understand the tools that we use to deliver the legal services. So ideally, we're not using tools that are not protecting our client information and so forth. Three, if we use vendors, we must competently evaluate that vendor. Ideally, my best advice to everyone is to have a security questionnaire and start implementing it. There's a lot of people and new shiny tools that are coming around in the market. Well, even before you plug them into your system and your environment, in your cloud, in your emails, please, at least, ask them the basic security questions and document your decision as to why you went with those vendors instead of others. And four, failure to keep up is a competence failure and not a personality trait. And another thing that I've been discussing as well, highly, is that at one point, in a year or 2 years from now, because of course, I've heard also attorneys saying that they're not going to implement AI in their law firms. They have their own opinions as to the implementation of AI. And what I've been telling them is that, in 2 years from now, it's going to be a disadvantage for their business, for their practice. Even their clients are going to see a disadvantage in the amount of money that they're paying that attorney and the amount of time that the attorney takes to, I don't know, let's say reply to a demand letter. If you could have used AI and you have attorneys in the practice already, answering emails in less than 2 hours, and you're still not implementing new technology to make those tasks easy, then they're going to start seeing a disadvantage in their business model, and not only, from the ethical side of things. Also, the ethical, we can chat about the ethical disadvantages as well, but I'm talking about the business side as well. And that's something that I've been trying to communicate to my colleagues as much as I can. So we are 30 minutes in and we are right on track for all of this. So the test for Comment 8 or Model Rule 1.1 Comment 8 is simple. So if a tool is relevant to how you deliver your legal services, you have a duty to understand the risk that that tool has. So for example, I am using AI not for the practice of law. I'm using it for the non-billable things that we all do on the daily. So one good example that I have a really, really good metrics on, it's for the creation of proposals. So whenever a client chats with me for 30, 40 minutes, I send them a proposal letter. It's going to be 2 to 3 pages long. They're going to understand, what I'm proposing, the fee, flat fees. I'm using flat fees these days more than hourly. And I explain everything to them really simple. In the past, as of, I don't know, February of this year, I was blocking a full hour of my time for every 30 minutes that I had a client meeting or a client consultation. I would spend 30 minutes chatting with the client and the other 30 minutes creating, the proposal itself. I will write it out. I'll be like, hey, this is what we're offering. Of course, we had a template, but I will spend 30 minutes, 20, 22 minutes modifying that template to the specific case. Now, these days, starting in April of this year, I automated that. So through open APIs and an AI person that helps me, an engineer, we created internal process that every time that I chat with the client through video, I get the notes, and the notes are taken onto Claude in the back end, and the system creates the proposal for me within 5 minutes after that phone call is over. So instead of me spending a full hour working on a proposal, the 30-minute conversation and the 30-minute proposal, it's only taking me about 38 minutes. So I'm saving good 20 something minutes per client per week. And in a week, I can easily have 10 to 12 client consultations myself. So you can do the math on the amount of time that I'm saving operationally, and at the same time, I also did my due diligence. So, I understand the risks of sharing the internal notes of a phone call, of the initial phone call with the system, but I documented those risks. I documented the amount of time that I'm saving, how much money that cost me. Like I did all my math, I did my internal risk assessment, and I decided that it was a good thing for my firm and where I'm at today. And those are the type of things that you have to be doing as per Common 8. So the most common Dutch, whenever I talk technology with lawyers, is that, hey, I'm not a tech person, but under Common Want, that's not defensible. It is a competence gap. And if you cannot explain how your client data is protected right now, today, well, we have a problem long before you had any breach. You need to start understanding your systems today. So these days, as attorneys, we need to be working closely with our IT teams. So Rule 1.6c, we're chatting about confidentiality now. Now this turns it from passive to active. In California, I think it lands through Rule 1.6 together with Business and Profession Code Section 6068E. So same destination, actively protect the data, don't just refrain from disclosing it. I think I got a Q&A. When you When you use AI to listen in on a phone conversation or video, do you advise a client before you start to avoid any issues of privacy violations? 100%, yes. So actually, one of the best things that I can advise y'all is not to have the AI note takers to join by default. I have it, on the screen, but I verbally tell the client and I see their demeanor. Some people are more comfortable than others. Out of 10 calls, I've had only like one people saying like, no, no AI, no takers, no nothing. I want nothing. Actually, I wanted to meet with you in person type of thing. So, it doesn't happen often, but the clients will feel more confident. So just don't have the AI note taker join by default. Have it join after you verbally notify the client ideally, and you're gonna be on the safer side of things. But definitely I use AI. This is a question that I get all the time. They're like, hey, do you use AI note takers? Yes, I do for Zoom meetings, for Google Meets, but I don't have anything on me that's recording. Another thing that I'm started seeing a lot here in Texas and I'm completely bothered about, it's the Plod little device. It's a note taker. It's really small. It's like this small. People are putting it on their wrists. They're putting it on their, on their clothes. You cannot even see it. And we're a one party, consent state. So they can just be recording anything and everything. And I'm bothered by it. I find it disrespectful. I find it, I don't know, unethical. I find all of it just completely wrong. But just please know that people are being more sensitive as to being recorded, as to being, without being disclosed, at least. So just be, even though that we're gonna see new technology, that how much a Claude device can help us. A lot. I mean, imagine not having to be like, I'm taking notes and forget about, turning the system on and off. That sounds like a dream, but at the same time, there's a lot of privacy and, data privacy concerns involved with these systems or devices. So please be mindful of that. Okay, so whenever we're talking about model rule 1.6, so basically, paraphrase, it says that a lawyer should make, again, reasonable efforts to prevent the inadvertent or unauthorized disclosure of or access to information relating to the representation of a client. So basically, we have to do our due diligence. We cannot be making blinded decisions anymore. Period. That was taken away the second that we got, new shiny AI tools and implementation of new technology thrown at us left and right. Reasonable effort factors. So, comment 18. One, we need to take into account the sensitivity of the information that we're protecting. Two, the likelihood of disclosure if no safeguards are employed. And again, we are attorneys. Even small law firms are most likely to get breached because of the type of data that we have in our systems. So we have more likelihood to be breached and attacked. Three, we need to take into account the cost of additional safeguards. We also need to be taking into account the difficulty of implementing those safeguards and whether those adversely affect the representation with our clients. So if we make it more difficult for them to, I don't know, upload documents in our portals and such. So perfect. Questions have been asked. I don't know if anyone has questions, please keep dropping them on the Q&A. I would love to answer any of your questions. So now we get into Model Rule 5.3, non-lawyer assistance. And here is where we get into third parties and third-party vendors, third-party vetting, uh, cloud providers, e-discovery platforms, AI tools, IT contractors, transcription services, billing, CRMs, so literally everything that we use, it's gonna be implemented by, a non-lawyer assistance and covered by Model Rule 5.3. Three questions that we have to answer whenever we're talking about vendor due diligence. What do they do with our data? What protections exist? And what happens if they have a breach? So how do we know the answers to those questions? Sending them a mini security questionnaire. That'll be the first and the best thing to do because one, it demonstrates that you try to take reasonable efforts to protect your client information, and two, you're documenting at the same time. So ideally today, tomorrow, on Monday, whenever you're more clear-headed, you should be counting the vendors that are touching your client data every day. And you need to be doing an inventory, case management, document management, e-discovery tools, all the ones that I mentioned. If you cannot answer these questions for every tool, you have a 5.3 problem right now, even before you got breached. Because the problems usually start happening way before, but we didn't even stop and audited our own systems. So the move is that, again, you need to start working on your vendor inventory spreadsheet. List the vendors, the data that they touch, the contract status, the last security review that you did to them, because that's another important thing. So I was working closely with a law firm here in town, helping them with their security, their incident response plan, their training. And they're like, oh, well, Majo, we are not going to need you anymore because you already helped us with the initial implementation. All our vendors have already the security questionnaires. They're audited. They're on the spreadsheet. You train our staff. You gave us the tabletop exercises. You trained the C-suite and the partners on all the security stuff that they should know. Your technical team came and audited our security controls. Thank you so much for your service. See you never. But the surprise is that you have to be checking your third-party vendors constantly because whatever they tell you on that security questionnaire today, or if they show you a SOC 2 compliant certificate, that might not be whole, that might not hold in time, in 2 years from now. So you have to check them accordingly. So once a year, at least you're sending the security questionnaires. You are rechecking the security certifications that they sent you and so forth. So it is a work in progress, as I like to call it. But that'll be a good project and a good homework if you want to really start working on security and vendor and your Model Rule 5.3. Now we're going to get into federal frameworks and industry standards. And again, the federal frameworks is for you to get a brief idea. There's so many of them, and it all depends on the type of law that you're practicing. So we've covered the bar rules, and now we're going to get onto the federal frameworks, which define what reasonable security looks like in the real commercial world. And then here's the good news for a room in California. These three, are federal, so it's going to be applicable as they are and as they stand, and you don't have to do any extra research. Of course, we've all heard about HIPAA. It's a hospital problem that it's not gonna, people think that HIPAA is a hospital problem and that will not touch law firms, but think about a personal injury law firm. They receive a lot of medical information after an accident. Do they have, are they HIPAA compliant with whatever security they have in place to protect the client's information? So HIPAA can reach three groups. The covered entities, the providers, the health plans, and then we have the business associates, anyone handling protected health information for a covered entity. That expressly also includes lawyers who represent covered entities or handle matters with personal health information, and subcontractors of those business associates. So again, if you are like my example, if you're a personal injury, medical malpractice, employment, even employment defense, healthcare M&A, you most likely will have access to the records which contain medical records. So now you're a business associate under federal law, and you have now a duty to protect that data. So we have now three categories of safeguards that HIPAA, imposes. So it's going to be administrative safeguards. So policies, we're talking about training, we're talking about risk analysis. Then it also requires physical safeguards to the facilities and the workstations. And it also requires a technical safeguard. So encryption, access, and audit logs. Who has access to what? We have to be auditing and, following that all over the place. And of course, we need the business associate agreements, and you're going to be also involved in those. So again, if you represent a covered entity that receives PHI, you are now a business associate, and you have a duty under HIPAA to control data as well. The GLBA safeguards rule, again, it governs financial institutions under the FTC, and financial in nature is broad, as we know. Mortgage lenders, I can think about tax, I can think about accountants, I can think about even, I don't know, I had even a franchise. I had a company that sells or provides a franchise fee to, they pay for the franchise fee whenever someone wants to buy a franchise through, I don't know, I think it is as small lending programs. So they advance the fee for the franchisor. And I thought, and I'm telling this because I really thought in my brain that because they were advancing the franchise fee to the company that they wanted to buy or the franchisor, they weren't covered under GLBA, but they are. So even things or scenarios that you think that are not touching GLBA safeguards maybe are. So I was neck deep last week onto this whole thing. So Even whenever we think that we're not, we are, under these federal regulations. So who is covered? Again, financial institutions, mortgage lenders, investment advisors, and I put it in bolded because it's now expressly covered, and companies that the FTC defines as financial in nature. So the GLBA safeguards requires that we have a designated qualified individual overseeing the program. And it's literally by name and last name. We cannot be like, hey, Castroland Legal, it's going to be overseeing the program. They can say, whenever they audit, if they go and do investigations on your WIS program, that it's not compliant, that it's not enough. So you need the Written Information Security Program. Basically, that's a version of an incident response plan specifically to financial institutions. These are really fun to generate. I love doing WIS programs. Three, you need risk assessments, you need encryption, you need access controls, you need two multi-factor authentication. And honestly, even law firms would need all of that. I've implemented a type of risk assessments and access controls one way or another within my law firm. And I recommend you doing the same. And four, it also requires vendor oversight and an incident response plan. I think I have a Q&A. Doesn't matter. Law firm hired outside lawyer to do collection case against former individual client. Can that client claim confidentiality breach from time records provided to collection lawyer without first getting written consent? No. No, because there's a rule, and I don't have it on top of mind, but there is a ethical rule that there are some of our ethical responsibilities are let go whenever we're going after a client for payment, or whenever we're called to the stand by a judge, to talk about something that the client was doing because of our representation. So there's something about it, but feel free to send me an email. My email is majo@castrolandlegal.com. I have it top of brain, and I'm going to continue thinking about it. But no, I would say no. Okay, new in 2024 for the GLBA safeguards rule, the FTC must be notified within 30 days of discovering a breach affecting 500 or more consumers. And good thing, now my question is for everyone in the room. Do you have a notification process? Because if you don't, then you are having other problems even before you get breached. Because whenever you do get breached, you're not going to even know where to start. You don't want to learn breach law, if that's a thing. I don't know how to compound it. You don't want to be scrambling through all of the breach notification responsibilities that we have, through the different bar associations and federal standards and, even high industry standards at the moment that you're going through a breach. Believe me, it's overwhelming to say the least. So please be working on your incident response plan and your notification process if you haven't. Another federal regulation, the de facto federal cybersecurity enforcer, the FTC, Section 5 prohibits unfair or deceptive acts or practices. So the FTC has used this for 20 plus years to enforce reasonable cybersecurity, reaching almost every business in commerce, regulated or not. Again, we're going to be seeing a lot of reasonable efforts, reasonable cybersecurity. But the good thing is that I do have a good answer for you if you were to ask me right now, which no one has, Majo, what does reasonable cybersecurity means? Well, I can point you to a couple in industry standards that I'm going to be chatting right after this page here. And you're going to have something to look at and something to follow. The reasonableness that we were discussing earlier, that's a trickier one. But we're attorneys, and I'm sure that you're going to be able to figure it out. So two enforcement theories are deceptive part of things. You said that you would protect their data, but you didn't. So example, a privacy policy on your website promises encryption, but under investigation, they find plain text storage. That's a problem. That's why our privacy policy, even on our websites, need to be really specific as to what we do with the data, how we store it, how we handle it, and what we do with it. So no copy paste from other websites. Then we also have the theory, the unfair theory. So your security was so weak that it harmed your consumers. So, for example, not having basic stuff like multi-factor authentication or patching leading to a foreseeable breach after a company or a system told you, hey, please click here to update and you didn't update on time. So that could also be another theory for us to be prosecuted under the FTC. Two simple rules: never promise more security than you can deliver, and never deliver less than what's reasonable. So those are the three federal frameworks, just to give you an overall idea on how other people's responsibility also leaks into ours. But I want to close the loop because I can feel the question, what does, reasonable actually looks like? And we don't have to guess that much. The industry standards that I was mentioning was the NIST Cybersecurity Framework from the National Institute of Standards and Technology, version I think 2.0. It has six functions: basically govern, identify, protect, detect, respond, and recover. A good incident response plan is going to follow those six functions. And I'm giving you already a tip for your incident response plan. So build it around the six functions of the NIST cybersecurity framework. Oop. Um, decided, oh, I think I got a question. How do you deal with the recent decisions that hold that information is not protected by the electronic climate? Oh, I love this question. Okay, so look, I was reading something really interesting. At least here in Texas, we got an opinion, I think yesterday or today, in where the judge said that, and I'm gonna put it on my LinkedIn after our chat today. So if you want to follow me, I'm gonna be posting about it. So the opinion, to paraphrase, basically the judge said, "Hey, by the way, client, because you were using AI as per your attorney's instructions, you are covered. So that's going to be covered as an attorney-client privilege because you were instructed by your attorney to prep for whatever they ask that person to prep." And then AI is not protected by the attorney-client when you use AI while communicating with the client. I think that's being, pushed to the side. I do think, and I see that if we're using AI and it's paid version, and it is if you have a DPA in place and you're not training their model, you're gonna be good. Those are my three questions to ask. So free versus paid, the data processing agreement in place, and no training of models. I think you have a good, not excuse, but a good you can make a case around that. You can literally say that you were using a system like we use Google and we research, but it's now called Claude, it's now called Harvey or whatever. But I think that judges are moving more towards and leaning more towards the idea that us relying on AI while under those three premises that I mentioned, we're covered and it's going to be considered attorney-client privilege. But I love that question because I was just reading that decision today here in Texas. I think we have about 8 more minutes. Okay, another industry standard that I will point you to if you're working on your incident response plan: ISO 27001, International Standard for Information Security Management System, certifiable. So when you vet a vendor, you can ask them, are you ISO 27001 certified? So even instead of you sending a security questionnaire, you can ask them for whatever certifications they have. And again, remember that you need to be asking those questions every so often because they can lose the certification. And three, the sys controls from the Center for Internet Security. It's a prioritized list of 18 specific safeguards. This is the one that I use. It's specific. It's ideal for solo or small law firms because we can actually implement it because it's tiered. We start with the basics. It guides you through like, hey, this is MFA, know your device, controlled access. So that's where I started whenever I opened my law firm and I wanted to start building my security controls. Of course, I have friends of friends that came and checked my security controls and everything, but that's a good starting point. The SIS controls. So take a look at the SIS controls, the NIST cybersecurity framework, and ISO 27001 if you want to start working on your incident response plan. So again, when we say reasonable efforts, we are not waving at something that's non-existent. We have a published bar whenever we're talking about reasonableness and cybersecurity. So we don't have to be certified, of course, but we have to know that they are the measuring stick of the standard, of the industry standard. And most of the regulations come from some version of those standards already. So, three things to take away with you. One, cybersecurity competence is a legal competence. It's part of what we do, even though that it for some is boring to me. I'm passionate about it, as hopefully you were able to tell through this conversation today. I love it. I love not necessarily understanding everything, but always reading and catching, opinions and catching the industry standards and chatting with the engineers and understanding this practice way more. Two, we need to have an incident response plan today. And three, we need to understand that reasonable efforts, it's a documented decision. You document everything, please, starting today and go back, start auditing your systems. Bernadette, would you recommend having language in agreement with provider? They notify you with 10 days if they lose any certifications. 100%. But I will think that 10 days is depending on the provider. But if you're it depends. It depends on who the provider is, but I think 10 days is kind of tight because they're gonna be trying to figure out and scrambling still, even if you were affected by it. But definitely similar language can be implemented. Thank you again. My name is Majo Castro. I'm located in Austin, Texas, and it was lovely to be, sharing this full hour with you all today and answering your questions. You can find me on LinkedIn. I have a Substack that is called the Cyber Law Gal. It's in English and Spanish. I chat everything technology. I chat everything privacy and AI as I know it with my, plain language. And I love the questions. So if you have any, you have my email here. Actually, it's Majo, Majo at Castroland Legal. Always happy to help my colleagues to get through security questions, even cases that you have and where you don't know how to handle some clauses. Always here to help, okay? So thank you so much again. Thank you for the Beverly Hills Bar Association for having me, and I hopefully will see you next time.